Welcome to the Daily Recap. The Supreme Court just made it easier to discriminate against minority voters, and almost nobody is talking about it. 6 justices, 1 decision, and decades of hard-won civil rights protections are now hanging by a thread. So here is the question you need to ask yourself. If the law meant to protect your vote can be quietly gutted from the inside, do you actually have a vote at all? Let's get into it. The United States Supreme Court handed down a 6-3 ruling that significantly weakens a critical provision of the Voting Rights Act. The decision came down along ideological lines, with the 6 conservative justices in the majority and the 3 liberal justices dissenting in sharp, emotional terms. The ruling targets Section 2 of the Voting Rights Act, the provision that for decades has been the primary legal tool used to challenge voting laws and district maps that dilute the power of Black, Latino, and other minority voters. Civil rights organizations, including the NAACP and the ACLU, responded almost immediately, calling the decision a profound betrayal of the civil rights movement. Democratic politicians echoed that outrage, with several using the phrase, "a day of loss for our democracy," to describe what had just happened. The ACLU said the court had effectively demolished a cornerstone of voting protection in America. The NAACP called it a gut punch to every person who marched, bled, and died for the right to vote. The 3 dissenting justices were equally blunt in their written opinions, arguing that the majority had twisted the law beyond recognition. This is not a minor procedural tweak. This is a structural change to how voting discrimination cases can even be brought to court in the first place. Here is why this hits different from your average court ruling. The Voting Rights Act of 1965 was not just a law. It was the legal backbone of the entire civil rights movement's electoral gains. Section 2, in particular, was the tool lawyers used every single election cycle to fight back against gerrymandering, voter ID laws, polling place closures, and any other tactic designed to make it harder for minority communities to vote. With this ruling, that tool is now severely limited. What does that mean in practice for real people? It means that if your state draws a congressional map that cracks apart Black neighborhoods to dilute their voting power, the legal pathway to challenge that map just got dramatically narrower. It means that advocacy groups like the NAACP now face a much steeper burden to prove discrimination in court, even when the discriminatory effect is obvious. It means state legislatures across the country, particularly in the South and in states with large minority populations, now have more room to maneuver when designing voting rules that favor one group over another. And let's be honest about the timing here. This ruling lands at a moment when voting rights are already under enormous pressure. Since 2020, dozens of states have passed laws restricting access to the ballot, citing election integrity concerns that have been repeatedly debunked in court. This Supreme Court decision does not just affect one state or one election. It reshapes the legal landscape for every election going forward. Civil rights attorneys are already saying their entire litigation strategy has to be rebuilt from scratch. To understand how we got here, you have to go back to 1965. The Voting Rights Act was passed after decades of systematic disenfranchisement of Black Americans, particularly in the South. Poll taxes, literacy tests, grandfather clauses, outright violence at the ballot box. These were not abstract concerns. They were the daily reality for millions of Americans. President Lyndon Johnson signed the act into law, calling it one of the most monumental laws in American history. For decades, it worked. Voter registration among Black Americans surged. Minority representation in government increased. Courts used Section 2 and the now defunct Section 5 to strike down discriminatory laws over and over again. Then came 2013. The Supreme Court's decision in Shelby County v. Holder gutted Section 5. the provision that required states with histories of discrimination to get federal approval before changing their voting laws. Civil rights groups warned at the time that Section 2 was now the last major line of defense. And they were right. In 2021, another Supreme Court ruling in Brnovich v. Democratic National Committee made it harder to bring Section 2 challenges. This new ruling goes further still. It is part of a decade-long pattern of the court systematically dismantling the infrastructure of voting rights protection piece by piece. So where does this go from here? Legal experts are predicting an immediate wave of new voting legislation in states that have been waiting for exactly this kind of green light from the court. Expect challenges to existing district maps to become harder to win. Expect state legislatures to move quickly. On the political side, Democratic leaders are already calling on Congress to pass new federal voting rights legislation, but that faces enormous obstacles given the current makeup of the Senate and the filibuster. Civil rights organizations say they are not giving up on litigation entirely, but they are pivoting toward state courts, state constitutions, and state-level voting rights laws where they still have more legal leverage. Some legal scholars are pointing to the 2026 midterms as the first major electoral test of this new landscape, warning that the structural changes in how districts can be drawn and how discrimination claims can be litigated will have a measurable effect on who wins and who loses. International observers are also taking note, with several democracy watchdog groups already downgrading their assessments of American electoral integrity in response to this ruling. Here is the bottom line. The Supreme Court just made it significantly harder to prove voting discrimination in America. Civil rights groups are furious. Democratic politicians are sounding the alarm. And the legal tools built over 60 years to protect minority voters are being chipped away, ruling by ruling. This story is not going away, and we will keep tracking it. If you found this breakdown useful, please like this video, subscribe to the Daily Recap, and hit the bell so you never miss an update. We post every single day. See you tomorrow.